Hello, my name is Francis Akinnuoye from Francis Law. In Alberta, in almost any family law situation where there's a breakdown of a relationship or marriage, the following 4 issues will likely need to be addressed: parenting, child support, spousal support, or interdependent partner support, or the division of family property. With respect to the issue of parenting, the parents are in the best position to be able to hammer out a parenting plan that works best for any children involved. Failure to do so will result in a stranger bearing the task of having to make a decision with respect to the day-to-day decision-making and care and control of any children when they are not proximally the most ideal person to do so. The parents are. With respect to the issue of child support, many parents sometimes forget that child support is the right of the child and not the right of the parent. Generally speaking, the amount of child support is prescribed in the federal or provincial child support guidelines based on the number of children, the annual gross income of the non-custodial parent, and where the parties are unmarried, which province the children resides in. With respect to the issue of spousal support or interdependent partner support, that theory is predicated partly on the idea that a clean break from marriage or a common law partnership does not exist. Since marriages or interdependent partner relationships are considered to be economic mergers between two parties, both parties have a duty to support the other in the event that a marriage or interdependent relationship ceases to exist. Just because your relationship ended, it does not mean that the more financially dependent partner must now be supported by the state. Accordingly, an award for spousal support or interdependent partner support may be found on a compensatory or non-compensatory basis. The compensatory basis occurs where both parents decide that one of the parents should abandon the public workforce to raise any children of the relationship. Consequently, if that parent has now lost the opportunity of a future employability, career advancement, or promotion, support may be awarded to that parent to compensate him or her for that early child-rearing decision made by both parents. A non-compensatory basis is where one of the parties suffers the greater economic disadvantage that results from the breakdown of the party's relationship. If that party requires financial assistance, support may be ordered payable by the party who has suffered the lesser economic adverse impact from the breakdown of the relationship to relieve the financial inequality that resulted from the breakdown of the party's relationship. You'll notice I use the word may and not must with respect to support, because unlike child support, spousal support or interdependent partner support is discretionary and not automatic. Lastly, with respect to the division of family property, generally speaking, and with some exceptions, most of the property that's acquired by the parties during the marriage or interdependent relationship is divided equally at trial or on a date agreed to by the parties in a formalized written agreement in the presence of independent legal advice for both parties. If you would like to know what the exemptions are or how the values of property are calculated, please don't hesitate to contact our office here at Francis Law, and we'll be happy to walk you through the steps and give you the appropriate advice for your specific situation. Be advised, the foregoing discussion is not intended to be or should not be construed as legal advice. It is presented as general information only. If you require legal advice for your specific situation, please don't hesitate to contact our office to book an appointment, and we'll be happy to discuss your situation with you. Until next time, Francis here from Francis Law. Have a blessed day.